Well, we can probably start things off here, everyone. Good morning, good afternoon, depending on where you are. People are still coming in from the waiting list, and I'll continue to admit them. But for now, I just want to do a quick introduction. My name is Mark Mancini. I'm the National Director of the Runnymede Society. We're very happy today to be hosting Justice Lorne Sossin from the Ontario Superior Court of Justice to discuss the viral nature of COVID and how it affects the justice system. We're very excited to have him here. I'm going to start by just, for those unfamiliar, just saying a bit about the Runnymede Society and who we are. And then I'm going to introduce Justice Sossin ever so briefly, and we'll kick things off. So the Runnymede Society, we're a national law student organization. We have chapters in basically every law school in the country. And we're designed to promote debate on issues relating to the rule of law, constitutionalism, and individual liberty. So we've been around for about 5 years now, and as part of our programming for the legal profession and for others who are interested, we're running a summer speaker series that features prominent people in the legal community speaking on important issues. So we've had 3 of those so far. This will be our 4th. And as it happens, we just yesterday launched a lawyers division for the Runnymede Society. So you can go to our website and find out more about that if you're a lawyer and how to join and how to take part. We're very excited to invite lawyers into the fold of the Runnymede Society. So with that, I'm just going to now turn to introducing our special guest, Justice Lorne Sossin, who was appointed to the Ontario Superior Court of Justice in December 2018. Prior to his appointment, Justice Sossin had quite the distinguished academic career. He served as professor and dean of Osgoode Hall Law School from 2010 to 2018. Previously, he was a professor with the Faculty of Law at the University of Toronto and a former associate dean at that same school. His teaching and research interests span administrative and constitutional law, civil litigation, legal ethics, and judicial process. He's published numerous books, journal articles, reviews, and essays, all sorts of issues related to administrative law. In the field he was a leader, and he holds doctorates from the University of Toronto in political science and from Columbia University in law. So with that, I'm going to turn things over to Justice Sossin. I'm just going to ask everyone if they can please mute their mics so as to avoid any technical issues. And we're very excited, Justice Sossin, to have you today to listen to your presentation. Thank you.
Thank you very much, Mark, and both for the warm introduction and, of course, for inviting me to participate in the speaker series and to the Runnymede Society and all the organizers. It's great to come together in this way. I was actually supposed to give a talk at a public law conference at the University of Ottawa today, and like so many people, those plans got shifted around. We're not all where we thought we would be, and we're not all doing what we thought we would be doing, but I'm very glad that you're taking the time to share this moment with me. And of course, it's important that we analyze what we're living through, knowing that living through a period of time may not be the best moment to reflect on it, to give it the thought that it's going to require to really make sense out of what's changing, what will endure with those changes. But at the same time, I think it's vitally important to capture the real-time thoughts and experiences and to share them. And I'm looking forward, even though you're on mute now, to some questions and comments to come. So if the tech gods are kind, I'm going to share the presentation. Hang on, let me try that one more time. And there we are. So actually first, let me give a shout out to Adil Munam, a graduating U of T student who provided invaluable research assistance on pulling some of this together. And I've told Mark if at any point the slides aren't visible or I freeze or disappear or can't be heard, to intervene. So otherwise, I'm going to assume that you can follow, you can see, and of course, I'll come back to any of these issues in the question period, given that I'm going to breeze over them a bit more than dive deeply into any of them. But I wanted to capture with the title the two senses of viral that I think are on our minds when we hear the term. One, of course, during the pandemic is all things related to COVID-19, to the phenomenon, the restrictions, the responses, the crisis, the new normal. But second, an emerging definition of viral, certainly for a number of years now, of things that go digitally and instantly to engage all of us in a shared image, concern, thought. And I think when I say it's justice gone viral, I'm really looking at it in those two senses and in the relationship between them, as so much of our world has come to take place in remote, virtual, digital spaces, and more on that in a moment. But in the spirit of a lunchtime talk, and again with the hope that you'll have a sense of the progression from start to finish, I'm doing it in the tried and true style of a top 10, so you'll know as I go along how many are left, and won't promise that these are in order of priority, but I think each dynamic, each aspect that was top of mind for me, I hope will resonate with you. And of course, these are not isolated. The relationship between them is perhaps more important and interesting than any of them on their own. So number 10, and again, one of the things that is not necessarily new, but happening in new ways, and that is the dynamic of live stream justice. And we've seen literally, and again, if you haven't tuned in for them, you'll know about this, that motions, applications, judicial reviews, and now trials are being conducted with increasing volume and sophistication by courts around the world, as the in-person courtrooms were suspended as part of the COVID-19 emergency. So whether by Zoom, Teams, WebEx, Skype, otherwise, the platforms all provide not only for the proceedings, but to broadcast them, often through YouTube or other kinds of webcasts. And some, like the Canadian Supreme Court, have embarked on Zoom for the very first time just within the last couple of weeks. The US Supreme Court famously held its first proceeding by teleconference, and what went viral from that were everything from sophisticated oral advocacy to flushing toilets. So you don't know necessarily what's going to be captured for posterity. Here we had the phenomenon fairly early on in April of the divisional court, which hears judicial reviews of administrative decision makers, subject close to my heart. And I think it was a judicial review involving one of the health college's midwives that attracted 1,200 people on YouTube. All the members of that college could tune in and hear and see what was being discussed really for the first time. So while we've had CPAC and cameras in the courtrooms, something is very different than putting that passive camera at the back of a courtroom and this image, which again, those of you who tuned in for the Supreme Court of Canada's first Zoom proceeding will have seen. Interestingly, and I'll come back to this, everyone robed, virtual backgrounds in a uniform way for all the judges. But this image, not of a courtroom, but of a collection of faces, I think is one of the enduring artifacts of the pandemic era. And I want to come back to its significance, what it says about the justice system in a little while. But generally, the points I wanted to highlight are arising from live stream justice. And I should add, I'm a consumer in addition to a content provider. I've had proceedings that have been shared on the various platforms, principally Zoom, that our court uses, that I've been discussing. but I've also tuned in to trials in Michigan, to appeals in Australia. There are no boundaries to the phenomenon of live stream justice, which is also something noteworthy. But I would say the key takeaways are enhanced public engagement, greater public awareness of the justice system, pressure to modernize when people see what really happens. Certain things that may not get a lot of attention suddenly are remarked on, responded to, so it creates a forward momentum to modernize. For example, the end of what's often referred to as practical obscurity, that technically certain aspects of the justice system have been open, but to very few people who could actually access it or know where to find it. So live stream justice is one where all of that is at our fingertips. And of course, with that come new concerns. And I've seen some court protocols now specifically dealing with what to impose in terms of restrictions and penalties for improperly recording images and using them for other purposes arising from these broadcast proceedings. And as I said, this idea of an image of the justice system becoming this collection of faces, there's an intimacy to that that's very different than the artifacts improperly attributed to Canada of a gavel, since we don't use gavels, or simply scales of justice or empty courtrooms or seals. There's something, of course, importantly human about seeing up close the advocates, the parties, or the judge interacting. Number 9, I've referred to as triaged justice, and I've posted here just one of the many orders and notices to the profession across the country and around the world in March, suspending in-person operations due to the emergency measures put in place arising from COVID-19 in Ontario. In the court I'm a part of, this meant as of March 17th, all those operations were suspended, and only urgent matters could move forward in this emergency period. Well, urgency is not unknown to the justice system, but it took on this important and intense new quality in terms of gatekeeping and triage. What could go forward, what needed to go forward in this period. And you see the reference in the Superior Court notice to urgent civil and family matters in this particular notice, and access to justice for the most urgent matters must always remain available. And our Chief Justice and others routinely intervened in a series of remarks and interviews to say the courts never closed. Courts cannot close. The rule of law cannot close. But of course, that means extra pressure on what gets through. So for example, in a oft-cited case in the last little while, the Thomas decision, 4 factors were identified that could guide this decision-making around triage. Is the concern immediate? Can it be dealt with later? Does it affect health or safety or economic well-being of parties, of course, most importantly, their children? Is it a definite concern rather than a speculative one? And is it one that can be substantiated through the evidence? In a criminal context, and this case comes to us from BC, again, there's a fairly long list of factors to be considered as courts tried to bring some consistency, coherence to what ultimately was an incredibly difficult judgment call around what would be heard and what wouldn't. So, number 8, and this flowed from that sense of triage, that sense of suddenly justice services being a new form of scarce resource, and enormous pressure to not allow backlogs to glut an already overcrowded, overburdened, overdelayed system of justice in many contexts and many jurisdictions. So one solution was to move things that would have been heard orally rather than just to video conference, which can only handle so much volume, but to simply move those to writing. And it gave rise to an interesting concern around whether the right to be heard, fundamental to our sense of fairness, of natural justice, could be satisfied with the right to be read. In the Ontario Court of Appeal, this took on particular resonance with an early decision to order a matter to proceed in writing over the objection of one of the parties. That gave rise to some strong commentary by Mark Gelowitz at Osler's and others to the effect that the Court of Appeal may not have the jurisdiction or authority to remove the right to be heard from parties, even in the context of a pandemic. And then as a counsel to a subsequent case, Mr. Gelowitz made those arguments, and they were soundly rejected by Justice Roberts in the SNC Lavalin decision, which, again, these are all hyperlinked, and anyone who'd like access to these slides and to go check out these sources, of course, will be welcome to have that access. But in the response to the decision, and again, aware of the advocacy both in and outside the courtroom by some counsel, Justice Roberts stated that it is well within this court's jurisdiction to order that a civil appeal be heard in writing when the due administration of justice requires it. During these extraordinary times, judicial resources are strained. The ability to hear appeals remotely is not unlimited, and so where appropriate, these orders will be made, and obviously this may or may not settle the issue everywhere, but for the Ontario Court of Appeal, this has been the last word. Now, the right to be heard or read has been controversial, but perhaps not as controversial as another proposal coming particularly out of a task force that the Supreme Court of Canada's Chief Justice Wagner co-chairs with our Canadian Attorney General and Justice Minister David Lametti, which will be releasing some guidelines shortly on court reopening and what this next phase will involve, but has already put out core principles and a set of foundational documents. But in an extraordinary interview on June 13th, the CBC reported that the Chief Justice was also indicating that amendments may be sought to the criminal code to facilitate how criminal proceedings could go forward. These included the potential for reducing juries from 12 to 6, and I should add, in many jurisdictions, civil juries already are 6, so this is certainly not unknown to our system. But also that jurors could participate remotely. They could be in different places, receive evidence by video conference. All of this would require legislative amendment. And I should add one other side to the story, just emerging over the last couple of days, some criticism from the bar around the Chief Justice in particular, making these comments about proposed law reform. But again, in that capacity on the advisory committee, all of this is somewhat uncharted terrain. So there's tentacles to each of these stories and slides, even if I don't have time to go through all of them. Provincially, and in Ontario and other jurisdictions, there's also been a proposal to eliminate civil juries, which I mentioned in Ontario are 6 altogether, or at least limit those juries to a discrete number of cases. Could be medical malpractice or other kinds of civil matters that there's a public policy reason to say requires a jury, whereas others don't. And in a supportive op-ed from a well-known Windsor barrister, the comment was that this would be advisable because the delays have become so endemic, so long, that justice delayed is truly justice denied. And the backlog, of course, is only going to exacerbate this. Number 6, and this now moves from some of the procedural dynamics to viral justice to some substantive ones, not just how we engage in the justice system, but the subject matter of that engagement as well. All the emergency legislation that has been proliferating at every level, federally, provincially, municipally, in indigenous communities, in the northern jurisdictions. All of Canada has had this flurry of new measures, some legislated, some executive orders, and I'll mention in a moment some through soft law, guidelines, and directives, and the like. What does it all mean? In almost every case, it's going to constrain things that people used to do, places they used to go, or the ways in which they used to go or do those things. So the infringement of what used to be a freedom is not an uncommon effect of public health measures during an emergency, especially the quarantines that have become so commonplace we almost forget. During SARS, for example, the thought of a quarantine was a major civil liberties debate, contested and arousing huge concern. Well, here that has become, again, just part of the background noise for many in the field. But the question of how far is too far has cropped up in a number of different settings. Some dealing with privacy rights and surveillance as we look at contact tracing and testing and screening and other dynamics, but principally around the right to mobility, to go where one has otherwise the right to go, particularly across provincial borders. And the Canadian Civil Liberties Association, the CCLA, and others expressed particular concern in and around the Newfoundland and Labrador measure to amend the Public Protection and Promotion Act, Bill 38, which restricted mobility into the province. And this led to Kim Taylor initially not being able to cross the border to attend her mother's funeral. That led to a lawsuit which the CCLA joined after its letter of concern did not change the provincial policy. And that was just filed May 20th. By June 3rd, there was a separate class action against these restrictions on entering the province. And by the way, it wasn't entering the province being restricted only. It was a process to seek an exemption from it that had a discretionary component. And even if you got in, there was still the quarantine and still other measures that were being applied. So just a couple of days ago, the Premier, Dwight Ball, said that this is still about safety and public health concerns, and they're not backing down. In the CCLA letter, which was prior to its lawsuit, and I won't read it all, but part of the concern was around what is based in evidence and what simply appears to be an overreach justified in some diffuse or broad sense by COVID-19. And the CCLA wrote, instituting even more severe restrictions on mobility, and this came fairly late in the pandemic, I should add, when the number of cases was quite low, authorizing overbroad police powers, even in the name of public health and safety, would require evidence of necessity and proportionality that do not exist. So some lines in the sand clearly being drawn around civil liberties. Well, I mentioned earlier that not all the measures are coming in a legislative and executive form that clearly affects the laws and the rule of law under which societies live. Sometimes we see signs like practice social distancing, which for those living in and around the GTA has become another set of codes. All you need to do is mention Trinity Bellwoods. People immediately think of a scene of young people enjoying a day in the sun that's become a cautionary tale around social distancing and led to lots of investment in chalk and circles in parks around the country. But is that a law to avoid contact in some circumstances, use caution in others? We've heard this around wearing masks in the last week or so, and it's led to the question for number 5 of my 10 dynamics of viral justice: when are guidelines law? When do these directives take on the force of law? Well, one of the ways we know that is when can they be challenged by judicial review or the mechanisms that we have for accountability over laws that bind social action. So 2 cases, and these are just samples. There's a number one could have reviewed of the soft law that has emerged through challenges in the various courts. One that's a particularly compelling example, Sprague, was a challenge to a hospital's policy of no visitation for vulnerable elderly patients. In this case, an individual's father he wasn't allowed to visit, didn't meet what were extremely narrow circumstances for visitation. The hospital said it was relying on a chief medical officer of health directive. So in this case, Mr. Sprague challenged both the hospital's visitation policy that he felt had kept him from engaging in what was critically important in his view to a loved one's well-being, and the chief medical officer of health's directive on which that policy was based. Well, the court found that neither constituted law, neither the hospital's policy nor the chief medical officer of health's directives were binding, were issued in a way that executive authorities could bind. And even though it led to, of course, a situation that in effect barred entry, this was not a product of law. Court, by the way, went on to analyze the constitutionality of these measures in case the court was wrong about that, and found no violation of the charter in those visitation policies or the chief medical officer of health's directives. But it's a very interesting case around the threshold for judicial review in soft law. In the air passengers' rights case, Justice McTavish of the Federal Court of Appeal was looking at public statements by the Canada Transportation Agency, basically saying that it may well make sense to only give vouchers or credits rather than refunds for airlines, given a host of factors. Well, anyway, this was challenged as well as seeking injunctive relief to prevent the CTA from pursuing this approach. And again, the Court of Appeal, Federal Court of Appeal, held that this injunction wouldn't be granted. The test for the injunction, particularly the first prong, was not met because Justice McTavish doubted that public statements by the CTA, again, not binding and not issued in a way that was a rule, could ever be subject to judicial review. And again, more on that if you're interested. All right, so where does that leave us? We've covered some of the procedural dynamics that have changed. We've looked at some substantive areas, but of course there's also critical areas that we need to be aware of that also may have enduring effect as opposed to temporary effect. And I'll come back to this dynamic of viral justice. We think of anything viral as time specific. It doesn't last forever. But I want to come back to that point. This image, by the way, is one of the few graphic illustrations of the digital divide. I'm not sure you can see there's books on one end of the chasm and laptops on the other, and a rickety bridge between them. And imperfect as that image is, the notion of a digital divide, the fourth dynamic that I want to highlight, is critically important and relates again to an exacerbated dynamic. It existed before COVID-19, but COVID-19 and these restrictions that put us all in remote and virtual spaces has shone a new kind of light on the different experiences people have with access to broadband, access to computers, laptops, tablets, and smartphones, access again to now what is not only necessary for education and for opportunity, but for accessing the justice system, an increasingly digital justice system. And in particular, those with existing vulnerabilities, whether it be through poverty, disability, race, indigeneity, all of the factors that already inhibit access to justice are having a disproportionately negative effect on communities through this digital transformation. So the digital divide is something we need to keep in mind. Even though we may be at 85.7% penetration of sufficient broadband nationally, translate that 15% into numbers, and it's an enormous concern. Never mind in rural communities where the majority of the population does not have, again, what the CRTC deems to be sufficient broadband. I mentioned earlier this action committee, the Chief Justice and AG are co-chairing, has listed some core principles. One of those principles is ensuring that the most vulnerable and those with limited or no access to technology also have their concerns taken into, factored in or taken into consideration as we engage in what access to justice will look like. And I only have time for a few more slides, and luckily we're on number 3. And this, again, moves to the question I've been hinting at. What is temporal? What is here to stay? Well, everyone has been quoting the "don't let a good crisis go to waste" line to ensure that while it's been abrupt and in some cases not without its glitches and fails, this move to modernize, to have more digital access is clearly not something that anyone is talking about reversing. And in particular, it doesn't mean we're going to have Zoom trials for the duration, but it will mean, I believe, and our courts are reiterating, and our ministries of justice are reiterating, e-filing, e-document management, online scheduling, screening, triage, no longer having to get 20 cases heard in a morning with lawyers sitting around just for the opportunity to schedule a matter in 6 minutes in front of a scheduling judge. These were never good uses of time, but very difficult to move the inertia forward from how things had always been done. Access to parties who need remote hearings is quite possibly going to be here to stay as another form of customizing or tailoring the justice system to the needs of diverse parties. And a greater acceptance of the success stories we already have with online dispute resolution, the Civil Resolution Tribunal in BC, Condominium Tribunal in Ontario more recently. These are resorts to important aspects of justice that haven't been affected at all by COVID-19 because they were already completely digital. So it's put a spotlight on this in addition to the live stream and broadcasting I mentioned earlier. Well, you knew there was going to have to be a CAT moment coming. And this, of course, is a representation or illustration of what we've all seen, which are some Zoom fails. I hope you're not seeing one right now, but we've all had to cut slack for a number of real-time challenges, dynamics that people are living through, living with, living under during this period. And this leads me to the second penultimate dynamic, which I've referred to as compassionate justice. That we, just in my own Zoom hearings, I've had snoring dogs, crying children, bad hair, both my own and others, dining room offices that still had some dishes from breakfast, of course, frozen faces, echoing voices, everything that could go wrong, I can guarantee you in some setting in the justice system has gone wrong. But this hasn't led to a breakdown of confidence or credibility in the justice system, quite the opposite. I think it's had the effect of heightening our compassion and understanding for what each other is going through and the differing ways in which this weight is borne during this intense period as, again, litigation and the justice system has to continue, but it's continuing in the midst of very busy home offices, very stressed individuals with, again, all range of challenges in managing. And I think it's also bred some new kinds of collaboration. I give a shout out to the Ontario Bar Association making available all the virtual courtrooms that the Superior Court of Justice here in Ontario has been using as just one example. All right. I told Mark I'll finish around 12:35, 12:40. So with that timeline in mind, I wanted to finish with the number one dynamic of viral justice in my mind, which builds on that last notion of compassionate justice, and its authenticity and the justice system. It's focusing on what really matters in the access to the rule of law, access to judicial dispute resolution and adjudication, access to court services. And even though we, apart from the Supreme Court of Canada, as I showed in the earlier graphic of their Zoom hearing, most of us have not experienced robes and images of courtrooms and court staff saying oyez, oyez, or order, or people standing or bowing. All of that may be expendable, even though those rituals come from somewhere, those traditions matter, and I don't see this moment as sweeping them all aside, never to find any way back. But they do show that we can move forward with a well-functioning justice system without them. Good advocacy, on the other hand, is not expendable and arguably more important than ever, even if it's going now to different platforms and through different mechanisms than many lawyers may have felt their comfort zone or may have felt trained for. And again, on the access to justice front, we need to recognize that it's been impeded and enhanced. There are people who used to be intimidated to come into a courtroom, or the challenges of getting to the courtroom were insurmountable, who now from a comfortable place in their own home can access those services, can give evidence or find outcomes that are vitally important to them. On the other hand, a number of judges have noticed, particularly in family law, some other settings, that certain kinds of cases that have been coming at a certain volume have dropped off precipitously. And the assumption is not that children are no longer in need of protection, or there's no longer important breakdowns and disputes requiring intervention, but that they're not coming forward. And that, of course, is another kind of accessibility concern we need to be mindful of. And the digital divide and all of the contexts that disproportionately affect certain people during the pandemic need to be borne in mind too. So as we finish, I wanted to end with a thought that there is a plus ça change moment we're living through. The idea that courts come to you, you don't necessarily have to come to courts, is as old as we're in the Runnymede Society event as the Magna Carta, where the practice of judges going on circuit really got its more formal start as a form of a rule of law protection. And the circuit courts in northern jurisdictions, rota judges still in BC, these are all part of the idea that courts are not fixed in place. But that doesn't mean that we have experience with what these digital spaces means and will mean for the future. And just today, I saw an interview with criminal defense lawyer Jordana Goldlist talking about, in her mind, the absence of humanity from these images on the screen. There's an antiseptic quality sometimes about just the lack of three-dimensionality, I suppose, the lack of human connection that happens only when we're in each other's space. And so I will finish with those concluding thoughts. The bottom line for me is that justice may have gone viral in all the ways I've been exploring, but it now has to become something else. I mentioned viral as a temporal notion, which by definition has an endpoint. Even though, as many will know, limitation periods were suspended in March and haven't been resumed, so time literally has stood still. It, of course, doesn't stand still in the broader sense. So we may have dealt with the first wave in a situation that we're now reopening, but what are we reopening to? What will this new hybrid phase of justice mean? And for those looking for a timeline, if January feels like years ago, I've put my sense of what the viral justice period so far looks like here to finish. And now I'm very much looking forward to your thoughts, comments, and questions. And Mark, I'll turn it back to you if you want to unmute, and I'll stop the share of the slides.
Great. Well, thank you so much, Justice Sossin, for that. That was really a great talk, and I think very informative for all of us. So with that, let's turn things over to questions. If anyone has them, you can type a question in the chat box, or you can you're permitted to unmute and share video, or just unmute and ask a question. So does anyone have any questions for Justice Sossin?
Hi, Justice Sossin. It's Gerard Kennedy in Winnipeg. How are you?
I'm doing very well. Good to see a familiar face.
Great to see you. I really enjoyed that and appreciated that, especially from a sitting judge. I'm particularly curious about the transition era in which we are in, and how cases that started under the expectation of a certain procedure may now be moved into some other type of procedure. And I am, as you know, I've been suggesting for a while that, you know, natural justice doesn't necessarily contain an oral hearing, and that in the interest of efficiency and actually improving access to justice for everyone, they can at times be dispensed with. But I also have, I guess, some concerns about a party expecting a particular procedure, making litigation's decisions expecting that procedure, and then having that changed on them midstream. I know you're also a lover of administrative law, and that's considered kind of a big no-no there. I realize we're in times of pandemic, but how do you kind of see the courts dealing with this issue of where a party says, okay, this might be a good idea in terms of responding to the pandemic and improving access to justice, but in this case, I expected something else?
No, and I think it's a terrific question. Students who are watching will, of course, know this from their own law school experience. If the evaluation is set in September, you can't just say in November, I've decided to add a new participation component because you're not talking enough. Or, fairness, I think, is something that we just come equipped with a sixth sense for. And I think you're right. During the crisis phase, I think the courts took the view that all bets are off, and being able to move forward, especially with these urgent matters, would have to mean move forward in the way that the court deemed appropriate. But I think that gives way in a hybrid context to some greater back and forth. So there will be cases in the backlog. And for example, if there's changes to juries or other things, we know from past experience with the Court of Appeals and some of the other changes we've seen, whether this applies to new cases or existing ones is a critically important issue. And my view is it needs to be addressed, and addressed in a principled way. And that principled way is probably no longer just going to be, it's an emergency and we have to do it this way, because now there is this hybrid ability, courtrooms are reopening. And so I think the triage will still happen. I think ordering some hearings to go in a fashion that the counsel or parties may not wish, I don't think we're done with. But I think that spectrum is shifting, particularly for cases where there are fundamental rights at stake, and in family and criminal settings. And I don't know that we're done with it, but I would imagine that shifting balance to focus more on those fairness questions and less on just the sheer emergency nature of a crisis and a declaration of emergency in the way that we saw. So I will be watching it as well. And you're quite right to say that this is going to be a question that counsel in particular are going to keep raising, particularly where they believe their clients will not get the same quality or nature of being heard in some other fashion.
Thank you.
Thank you.
Okay. We do have one written question here for you, Justice Sossin, so I'll just read it. Hello, Justice Sossin. That was a very interesting presentation. Thank you. Do you think that jury trials could one day happen over video conferencing? Do you share concerns of some lawyers that credibility of witnesses would be more difficult to assess over video conferencing?
So, I think those are two separate questions. I think we may well see some remote juries if, again, depending on whether it's civil or criminal, and depending on whether there are amendments, if necessary, to allow them. But I see that as different than the question on credibility. And again, I think the backlog in the criminal context in particular is weighing heavily on everyone making decisions. But I'm less convinced that credibility is an assessment that turns on being in a room together. I've never been persuaded, for example, that for example, experience of counsel that's visually impaired, that doesn't see the body language or physicality of a witness, is any less able to cross-examine or less effective, or a judge who doesn't have that ability to see a witness is somehow not able to make a credibility finding. I think there are a number of these dynamics that are at play. It's not to say it's unimportant to be in the room together. And I've heard a number of counsel say being on the telephone is certainly very different than having that ability to see each other and connect. So all of these are important, but I don't accept that credibility depends on a particular sense being at play, hearing or seeing. As long as the communication can be effective, and as long as the assessment of the evidence can be undertaken, then I think the system can function and will function. But in my view, the credibility already has concerns that arise from the attempt to read demeanor or read body language. So I think it's a trade-off more than it is one form of interaction just being inherently better than another form.
Yes, I see Mr. Howard Knopf.
Yes, can you hear me?
Yeah, we can hear you.
Good morning, Justice Sossin. Wonderful to see you and to hear you. Thank you for the wonderful talk.
Good to see you.
Thank you. I might be putting you improperly on the spot here, and I'll certainly understand if you want to duck the question. But since the Chief Justice of Canada seems to be, stepping into the limelight, I'll give you the chance as well. There's a bill pending in Ottawa now that some of you may or may not be aware of. It, at first glance, would seem to have more federal implications, but not really. It's Bill C-17, and I posted a link to it. And this bill, for those of you who may not be aware of it, would basically suspend any limitation or prescription period in a proceeding pending before a court. I don't know how it can do that for provinces, but you said that that's already happening in Ontario. And it will suspend any time limit in relation to something that needs to be done, and any time limit within an application for leave to commence a proceeding. Now, this will deal with federal acts. So, for example, as I understand it, it would, and it on its surface is retroactive. It goes back to March 13th of this year, and it would suspend everything until September 13th. So, as I understand it, it would suspend, for example, leave to appeal deadlines to the Supreme Court of Canada. In terms of limitation periods or other things, it may have implication on provincial proceedings, because some proceedings, such as the kind I deal with, copyright infringement, for example, can arise either in the federal court or the Ontario court. And some of us are concerned that this may be a solution in search of a non-existing or vanishing problem, because as you've pointed out so eloquently, and others have too, the courts are doing a wonderful job of coping with a very, very difficult situation, and have brought us back to something approaching normal, and maybe even, hopefully at the end of the day, better than normal. So this will inject, I think, a lot of uncertainty. The subject came up at a recent online town hall for the IP bar with Chief Justice Crampton, and I planted the same question, and he didn't really want to answer it. This was before the Chief Justice had started speaking out. His body language suggested that he had some concerns with it. And I think maybe he used the word vague, and he said, I really can't talk about it because these issues may come up in front of us. So with that long preamble, do you or any of your colleagues in the Ontario court that you may have spoken to have any concerns about this bill, which, by the way, has just got through first reading, and where it goes from here, who knows, because there are no more scheduled at this point sitting days in Parliament, and I'm no great expert on the subject of retroactive legislation, but my understanding is that Parliament can be very retroactive if it wishes, but it has to be extremely, absolutely, ridiculously explicit about it to make that effective, because otherwise it won't be effective. So well, here we got it's retroactive on its face to March 13th.
No, I was going to say the same thing, that the case law that we do know dealing with retrospectivity or retroactivity does put the premium on clarity, and the vagueness question is really where the mischief can come. So the limitation periods being on hold, given the fact, for example, that only urgent matters were going forward in Ontario, meant that if your matter was urgent because a limitation period was pending, those cases could all be set aside until such time as the clock starts again. And I think that was an important element of clarity. The other question, though, is does it lead to unfairness or a disproportionate impact for some? And this is what I think we'll need to focus on, that wasn't necessarily on the table, because the decision, at least provincially, came very early in the course of the COVID-19 emergency declaration and follow-up notices and restrictions. So for me, the issue is one of clarity. It's open to Parliament to do a whole range of things that affect the justice system in that sense, particularly the civil system. But the idea is that it should also be open to challenge. And for that reason, like the Chief Justice, I wouldn't want to comment on the pending legislation in particular, because it could come in one shape or another before a number of courts. But I think that's an important dynamic, that just because these are happening in emergency times, just because they're happening with public health or access to justice justifications, doesn't mean that they're immune from scrutiny or accountability. And that will also turn on a better understanding of impact. So if it turns out that this kind of legislation has more impact on some than others, or particularly harmful effects in actual cases, and the evidence is there to show this, I think that all will put new perspectives on what's happening, and the remedies are the same old ones we have in our constitutional democracy, where Parliament does have, again, a range of says over these matters as a reflection of that democratic will. But there are always limits, whether federalism, charter, and in other contexts that affect the rule of law. And there's been, again, other jurisdictions where limitations haven't been suspended. And I saw a chat coming, a note looking at, I think it was Ireland. So comparing, again, that impact where there is that evidence may well be important as well. So I think the question is an important one, an open one, and I hope one that we don't lose sight of, particularly as we get more data, more experiences and impacts that will shed more light on what exactly this means for different kinds of litigants. So thank you very much.
Yeah, thank you. I mean, I just sort of follow up. Some things I suppose I can understand in theory why it might be a good idea to suspend some limitation periods if it's hard, if you're getting near it and it's difficult to do an investigation or whatever. But for something like a leave to appeal, which to the Supreme Court, which is a paper exercise, I don't really see any reason why that has to be subject now to a great deal of uncertainty, especially maybe retroactively. and there are some interesting cases pending now.
No, and look, I think your skepticism and asking probing questions, that doesn't mean you don't respect the need to adapt in a general sense, is absolutely the important way to continue to be. I think we're going to need vigilance from the bar, from the key players in the justice system, and from parties who are affected by this, if we're going to get a handle on what this new hybrid phase in particular is going to look like, where it's no longer a crisis. At what point does time start running again, or does the retroactivity become, if it's not passed until September, back to March? What problems does that gap in and of itself give rise to, are all the issues that I think we're going to need to better understand. So I hope there are others like you that are not taking things on leaps of faith, but asking hard questions and looking at the reality that you see in front of you, because in my view, that is the hallmark of how we move forward in our justice system. It's a particularly challenging time, but it doesn't mean that there aren't lines that still need to be important boundaries within the justice system on a host of areas. So I will watch it as closely as you are. And again, won't comment on the particular legislation, but will be, I see this as part of a broad range of measures that will have to be justified and are being justified, and no doubt in subsequent inquiries and litigation will be held up to a different kind of scrutiny when we're no longer living in the midst of the moments that we're now in.
One other...
I'm sorry.
Okay, I've used up my time. Okay.
Yeah, I just want to, we only have about 5 more minutes, I think, for questions, so I do want to move on, get some other questions in. Thank you for your comments. Anybody else have any questions? Maybe not.
Well, then maybe I can squeeze mine in. Justice Sossin, you talked about online documents. Everybody's concerned about that. And I'm concerned that we've got about 10 or 12 separate silos going on in Canada in the various systems right now. Why don't we have something, why haven't we years ago developed something like the PACER system in the United States, where anybody can access any document instantly for a very small amount of money? Some people say even that's too much. But why do we need to reinvent this wheel 12 times in Canada?
No, and the debates, first of all, I think that's absolutely right. If we're going to do this, the question is, do we do it right, or do we do it in a way that can work for now? Because some of the former requires design and user-centered, mechanisms to make it sustainable and have it respond to all those needs and be done in-house. There's off-the-shelf kinds of services as well that some say we can just use tomorrow and get it working. And I know every court that hasn't already implemented forms of electronic document management are wrestling with this balance. And it may be a little bit of both. It may be some things that get us through a crunch time period, and then a broader commitment to developing exactly those kinds of measures that have as their goal the most effective and user-centered approach. And so it's like the same with the live stream. Should there be a webcam in every courtroom? There's going to be no doubt debates coming out of this about where and why we would limit that kind of access. And I think we're going to see it in a range of digital contexts, including documents and access to them, where these are not new choices. We've always had to wrestle with open courts, and we've always had to wrestle with how to manage all the information and data coming in, and concerns for privacy, and where there's court orders that are sealing some information. All these things are critically important. But I think this is going to have that blue sky quality, that now that we're moving forward and there's a broad and shared commitment to do so, what's our endpoint and how are we going to get there should be the kinds of discussions that are happening, and in my experience have been the kinds of discussions happening. But when you overlay scarce resources and time pressures and realities of public sector governance and all the different stakeholders and people who play an important role in the system and get a voice, then it certainly won't be a linear process or self-executing. It's going to take a lot of work, thought, and discussion. But certainly from my own point of view, until and unless there's a reason not to provide that kind of access, I think transparency is our goal. And that's part of the justice system's commitment to being seen to be done and not simply being done. So again, I thank you for the questions and look forward to the shared conversations to come online and hopefully one day soon in person.
We do have one more question, Justice Sossin, if that's okay with you.
Absolutely.
Okay, so this will be the final question. Has there been any guidance provided to court employees regarding security in the use of Zoom? I guess for hearings, given that it has been banned by the U.S. Senate, NASA, and Google and other organizations?
No, it's a good question. And again, as in all these things, you know, I'm speaking for myself and my experience, not as a representative of my court or any court, but certainly that issue of encryption, of end-to-end security is a critically important one. And I should add also accessibility, that the platforms allow for those with visual impairments or hearing impairments or other experiences with disabilities to access them in again, different functionalities. So all these issues from safety and security, privacy, accessibility need to be part of the assessment. And what we found is there's often a trade-off that no platform is perfect. All of them have some elements that are effective and some that aren't. So for example, in Zoom, one of the issues that there has been discussion around is when there's a recording, that it not necessarily, you know, not be a recording to a cloud, but a recording to a device that can be then circulated. Those kinds of very in the weeds questions go to some of the areas where a focus on not necessarily removing risk, but mitigating risk, recognizing where there is strengths or weaknesses in security and in these other areas has been very much a top of mind concern. But I would also add it's not static. The point of this talk has been the dynamics of viral justice, and I've seen it evolve, but even in the midst of lots of expansion, and Zoom is the platform that the Superior Court of Justice is using, but Teams and WebEx, other platforms are being used elsewhere. So like in my response to Howard, once we have that data and start to see which is really able to provide that sense of accessibility and security and functionality, I think we're going to learn a great deal about if this hybrid era is going to endure, where those choices and decisions need to be made. So I think the questions really highlight exactly what we need to be focusing on, and the experience of other jurisdictions is an important data point as well to consider. So as I said, I'm not the decision maker for our court, but I am one of the many people who asks questions and listens carefully to learn from how best to proceed, where the options, again, don't include the perfect, but include a range of what will get us through this period and make sure we can function and safeguard the important rights at stake as well.
Great. Well, thank you so much, Justice Sossin, for the talk and your answers to the questions. Thank you to everyone for attending today and for those great questions, great discussion. With that, again, Justice Sossin, thank you. And we'll close out today's session. If you want more information about the Runnymede Society, please visit our website, and my email is there. You can get in touch with me with any questions you have as well. So thank you, everyone, and have a good rest of the day.
Thank you.
Wonderful to see you, Justice Sossin. Take
Thank
care.
you.
Have a good day, everyone.
Thank you.